All right, welcome back to part 3 of our riveting sovereign citizen lawsuit. I've had a great time doing this one. I hope you guys have enjoyed it too. And I say part 3, but it's actually the 4th video we've made on these morons because the first one was their a motion in their foreclosure action, which isn't in this lawsuit. Either way, I made a playlist, so this will be the 4th in that playlist. If you haven't watched the previous videos, go watch them, then watch this. It just makes sense to do it that way. But for those of you who are new, well, go back and watch those videos, and you'll hear me say this in those videos. I'm Joe. I'm an attorney licensed to practice in the state of Utah. All this nonsense is happening in Florida primarily. At least the lawsuit itself is, but it has reaches into other states for reasons. But either way, the parent lawsuit we are covering is the uh, the bankruptcy of the United States Corporation Company. This is an involuntary bankruptcy that was filed against the USCC by the sovereign citizens. They're more sovereign citizens. And as we've discussed, you can put someone else into bankruptcy. That doesn't mean that they will be, receive a discharge or a reorganization. They may file a motion to dismiss because, hey, you don't owe them money or you're caught up and, don't, whatever. So, spoiler alert, that's basically what USCC did is they filed a motion to dismiss. So we have covered the main document, the involuntary bankruptcy petition. And at some point I should pull up a proper chapter 11 petition, cuz you may remember this one was only like 4 pages. It was missing so much stuff. Although I've never actually filed a involuntary petition. I've never filed a chapter 11 myself either. I've worked on them, but I've never filed one. But there's a lot more stuff that would usually be in a chapter 11. Hell, even a personal chapter 7 is going to be more than 4 pages. I have filed those. So either way, we've covered that and we've covered several of the attachments. So we left off on document 1-7, which would be the 8th document. And this appears to be a complaint in the 4th Judicial Circuit in and for Duval County, Florida. So it's state court. I'm going to skip this one. I may come back to it in a future installment, but this is 76 pages. I'm not prepared to go through it right now. But it has that, it has page after page of defendants. And for some reason, it goes up to 129 in the list here in Arabic numerals, but then at 130, it switches to Roman numerals because CXXX is 130. So 129 in Arabic numerals, 130 in Roman numerals. And it proceeds all the way down to CLXXX. I believe that's 180. My Roman numerals are lacking. I think L is 50. Either way, it just page after page of defendants, and it's all frivolous. It's all absolute nonsense. And so, like I said, I'm not going to go over that one today. I have no idea what it's about, even having scanned it a little bit. It is handwritten up here. Timothy J. Corrigan, one of the defendants, who I believe is works for the United States prison system, but Timothy J. Corrigan unlawfully removed this case from Duval County Court record and unlawfully placed said case in the U.S. District Court with the address, causing an abundance of irreparable harm and numerous concrete injuries to executors. I mean, if you file it in the wrong court, if you file it in state court and it should be heard in federal court, guess what? It's going to be removed to federal court. So next, I'm going to skip this one as well, 1-8. Feel free to look these over. You know, it's easy enough to find this on Court Listener, free to pull up. But this is an affidavit of information report and preferral of charges, criminal complaint for war crimes, felonies, high crimes, and misdemeanors, a delict penal action. I don't know what delicious genitals have to do with anything, but it's an appendix. So I think it's dealing with the same as the previous nonsense, except it's double the length. So once again, I'm not prepared to go through that today. I might come back and do part of it in the future. No promises. And the final one I'm going to skip for today is this final judgment and civil orders, April 11th, 2014. It's also 78 pages. And it says final judgment, but it looks like it's just some nonsense filed by the sovereign citizens, by the Moors, in the presence of God, Pope Francis, and the world. Let it be known. And it just absolute nonsense. This one could be fun to go through, but like I said, I'm not prepared to do it today. So where does that leave us? Well, we've still got plenty to go through. So we have these emails, which we were tipped off about these emails either in the last video or the one before, because the moron said, you know, I was brutalized by the U.S. Marshals, meaning he was arrested, and the pictures and blah, blah, blah. And so we have emails with Larry LDB Brown, who is a deputy U.S. Marshal, between him and Eddie something or other, Patricia Mezon, and it's subject, pics and prints, attachments, something or other, pick and print. I can't read that. It's a bad scan. Either way, every mention of him in handwritten with an arrow pointing at Larry Brown's name. Apparently he's a war criminal, because yeah. And the email, Eddie/Patricia, don't let the pictures fool you. Although at first, when told he would be processed, he refused. The faces he is making in the pictures are him straining and contorting his own face voluntarily. So he's trying to puff up his face to make it, oh, look how bruised and swollen I am. He offered no resistance except to tuck his chin into his chest. As soon as he felt the hand underneath his chin, he very agreeingly lifted his head and began straining as if he were being forced. He even laughed a few times, sticking his tongue out while we were taking his photos. He thought this was a game. He was under no duress. Call me if you need anything else. Respectfully signed, Larry LDB Brown. That's hilarious. And they're terrible scans of the pictures, but it really does look like he's making faces. This isn't swelling. It's just hilarious. And this one is upside down for some reason. Well, it's because I had to. It's because the other ones were sideways. And then this one is from Larry Brown, war criminal, to Daniel something or other at the U.S. Marshal Service, and Patricia Mazur, same person. Subject, Taekwon Gullet, our sovereign citizen. On February 7th, 2015, State Department agents from Fort Myers, Florida, produced a new arrest. Hephzibah Cysteria Hephzibah was arrested for fraudulent U.S. passport applications. Hey, look, consequences of your actions. I kept saying, hey, look, I'm petty. If I were a prosecutor and you handed this to me, I'd charge you. Every single time. A sovereign citizen, if police pull them over and say, I need your license and registration, and they hand you a packet of paperwork. I asked you for license and registration. You handed me bullshit. Charge. It's... And especially when they do the, Kingdom of God passport, Kim Blandino bullshit. It just, yeah. While processing Hephzibah, she provided deputies with information as to her family. Malik Rochelle was identified as her son and resided at the same address. This is a terrible scan, and I don't think blowing it up is going to help because it just makes it bigger and pixelated. While Hephzibah was in U.S. Marshal Service custody, two individuals appeared on her behalf at the front window of the U.S. Marshal's office, Jacksonville. They requested assistance from the U.S. Marshal Service in filing documentation to the U.S. Clerk's office. One of the individuals identified himself as whatever it is, Rochelle, Malik Rochelle, or Masik Rochelle. Like I said, it's terrible. The U.S. Marshal Service denied them their request. However, they basically they took a copy of what they intended to file with the USMS. Shortly thereafter, Assistant U.S. or Deputy U.S. Marshal Brown was contacted by the chambers of Judge Patricia something or other in reference to emails received from Malik Rochelle. I had sent pseudo court filings directly to the judge's email that were of a sovereign citizen nature, or L had. Yeah, I think it says L had, not I had. So Malik Rochelle. So L had sent the pseudo court filings to the judge. It was later determined that L's mother, Hephzibah, and he are involved in a sovereign citizen movement and both identify themselves as sovereign citizens. They do not acknowledge the federal court's authority. Brown researched, and Brown, the deputy U.S. Marshal, researched L in order to open a something case on him. In doing so, Brown identified Malik Rochelle as the AKA for Taekwon Gullett. Gullett is a black male, 5'11", 215 pounds, date of birth, and blurry social security number. So remember, this is, we don't operate a petting zoo. We are a animal safari. Keep your arms and legs inside. Don't contact anyone. Don't take any of their personal information. That's a douchebag move. So when attempting to place Gullett in something or other as the sender of something, it was discovered he had a previously established something assigned. Deputy U.S. Marshal Brown researched it and found that Gullett had a sealed warrant for his arrest, or that might be valid. Once again, this is a terrible scan. But he had a warrant for his arrest out of I think that's it's C/CA, so I'm guessing that's the Central District of California, for false, fictitious, and fraudulent claims against the United States, retaliation against a federal law enforcement officer by false claim, or slander on title, causing an act to be done. Title 18 USC Section 287, and a few others. The warrant was issued by the something in C/CA. Brown contacted the lead investigating agent of the IRS in C/CA, Patricia, who we saw in the previous email, and notified her of Gullett's location. Mason, Patricia Mason, contacted the U.S. Marshals in the Los Angeles Division of Central California and requested their assistance in arresting Gullett. Brown was contacted by Deputy U.S. Marshals, I think, or in California, who stated they are sending a collateral lead for the arrest of Gullett while he was in Jacksonville. Please contact me if you have any questions. Respectfully, from Larry D. Brown, Deputy U.S. Marshal. So, and then for some reason we have stuff about FCI Coleman and the Judge Timothy J. Corrigan, basically looks like Google, some, I don't know what it's from. Either way, it's irrelevant. But that's good to know. If I run low on content, I need to do a search on Pacer and find his other cases, like maybe his criminal cases, because that could be fun, or it could be a waste of time. We'll see. But either way, so, and then we have similar on Judge Angela C. Dempsey. And this is State of Florida versus Cyteria Hephzibah in the Circuit Court for the Second Judicial Court, or Circuit in and for Leon County, Florida. And this is an order from the judge. Order adjudging defendant incompetent to proceed and placing defendant on conditional release. So Hephzibah Cysteria Hephzibah is incompetent to stand trial as of 2015. So this cause having come to be heard before the court, and the questions of the competency of the defendant in this cause to proceed having been raised in accordance with the provisions of Rule 3.211A, Florida Rule of Criminal Procedure, and S 916.12, Florida Statute, 1998, the court appointed Dr. Martin E. Falb, PhD, PA, to examine the defendant and to report to the court on whether the defendant is competent to proceed, and, if not, to report on any recommended treatment for the defendant to attain competency to proceed. The court, having received the written reports of the above-named experts and others in relation to the issue of the defendant's competency to proceed and need for treatment, the court hereby makes the following findings of fact and conclusions of law. Findings of fact. The defendant suffers from a major mental illness. And that's sad. I don't know if she, what it is. It might say, it might not. I think sometimes courts and even medical practitioners are too willing to say, look, you're not mentally ill, you just believe bullshit. Sovereign citizen thinking isn't a mental illness. It's just you're gullible or desperate or something. But I think judges are too willing to say, well, they're incompetent, and punt it down the road. I'm not saying that's the case here. She very well could have a major mental illness, and that's sad, but she should be committed then. Bring back asylums. Seriously. Don't, have them humane and staffed and, but we need to bring back public asylums instead of having the revolving door of homeless, mentally ill people in and out of the court system, when the reality is they are incompetent, and that's what makes them end up on the street as drug addicts, because so often they're trying to self-medicate and they'd otherwise be in the asylums. So, let's prioritize spending money on actually making things better instead of the revolving door of the prison industrial complex. But either way, rant over. Second finding of fact, the defendant is incompetent to proceed. 3, the defendant is in need of competency restoration training, and such training is available in the community. The defendant does not meet the criteria for placement in an inpatient program. Conclusions of law. The defendant is incompetent to proceed due to the defendant's mental illness as defined in Florida State Law 916.10611, Florida Statute 1998, the defendant is incompetent to proceed with pretrial hearings, entry of a plea, the trial of the case, sentencing, violation of probation or community control proceedings, hearings on issues regarding the defendant's failure to comply with court orders or conditions, and other matters where the mental competence of the defendant is necessary. The defendant does not meet the criteria for commitment to a treatment facility of the Department of Children and Families as provided in 916.13.1, Florida Statute 1998, but is in need of outpatient treatment to restore competency to proceed. Based upon the findings of fact and conclusions of law, it is ordered and adjudged that the defendant is incompetent to proceed due to the defendant's mental illness as defined in the statute, and all further proceedings are hereby stayed. The defendant does not meet the criteria for commitment to a treatment facility of the Department of Children and Families as provided by state law, but is in need of outpatient treatment to restore competency to proceed. Accordingly, the defendant is hereby released pursuant to state law and rules on the following release conditions. The defendant shall meet with his assigned case manager, competency restoration specialist, as required for the purpose of monitoring compliance with the conditions of the release. These meetings may include scheduled office visits or scheduled and/or random home visits. The defendant will reside at an address in Jacksonville, Florida, by herself, brother Arthur Newsom and his phone number, and Pastor Bertie Vreen's phone number. The defendant shall not change his address/living situation without prior written approval from the judge who maintains jurisdiction over his case. The defendant will take psychotropic medication as prescribed by his treating psychiatrist. The defendant will not drink alcohol or use illegal substances. So, yeah, basically standard pretrial release plus ordering compliance with the mental health attempts to restore the defendant to competency. And the forensic team at Appalachia Center shall be responsible for facilitating an interstate forensic transfer to the appropriate agency. So that's who's responsible for it. The defendant will be released to her brother on April 30th, 2019. The defendant understands the conditions. Should the defendant fail to comply with the terms of his/her conditional release, this order directs all sheriffs of this state to render aid and assistance in the arrest and detention of the defendant and detain him/her pending transfer to the Leon County Jail. So, and the court hereby retains jurisdiction in this cause pursuant to state law for the entry of such order as may be necessary or appropriate. And that's from Judge Angela Dempsey, Circuit Judge. And I have no idea why this has been included as a filing in the involuntary bankruptcy of USCC. I have absolutely no clue what this has to do with any of it, other than to say, hey, look, I'm mental, therefore you shouldn't hold me in contempt for filing a frivolous involuntary bankruptcy because I don't know any better. Is that why she filed this? I don't know. I don't know. And then this is the conditional release plan, which looks like it was it was made alongside the order and basically for the defendant to sign saying, yeah, I understand the conditions. This is binding. So, yeah, that one was not quite as interesting. Not, at least, it wasn't funny. Like I said, I don't know. Is she delusional? Does she suffer from mental illness, or did was the psychiatrist, psychologist, whatever, just not familiar with sovereign citizens, and she's spouting sovereign citizen nonsense? And he's like, yeah, she's a Looney Tune. She's, queer as a $3 bill. I don't know, because once again, it sounds nuts, but it's a belief system. It's based on delusional rantings, but other people believe it, and it's wishful thinking. It's desperation. It's not incompetence, at least not of the legal sort. So I have my doubts, but she very well could be incompetent. I'm not saying she's not. If she is, that document wasn't funny at all. If it is just, the psychologist not being familiar with sovereign citizen rantings, well, then it's frustrating and not funny. But either way. Next, docket 1-12 is, we have some notices of hearings. I don't understand, once again, why these are here. They're, yeah. And then something about the Office of the Attorney General in Florida, which, from Entity Dashboard. So this is probably the Dun & Bradstreet download. So either way, once again, I have no idea why any of that was provided, but then we have FCI Dallas or FCI Tallahassee. I don't know why I said Dallas. And Honorable M. Morales Howard. Once again, no idea why any of this. Oh, this is why I kept this up. So, Cysteria Hepzibah has been granted a discharge under 11 USC section 727. Cysteria Hepzibah, aka highly favored Shekinah L, aka Cysteria Hepzibah L, aka Cysteria Lawrence, DBA, Cysteria Hepzibah, DBA, Hepzibah Cysteria, on November 7th, 2018, by the court, Karen K. Specie, United States bankruptcy judge. So, remember from the first video of the series, but the second on the playlist, the first video we did on this case, 11 US code, that means it's in the bankruptcy code. 727, that means it's chapter 7, and 727 is, see, I still have my handy dandy US bankruptcy code here, and 727 is discharge. So they have received a discharge on a chapter 7 bankruptcy. That is the full-blown goodbye debts, except for secured debts or student loans. I highly doubt they have student loans, although, educated people do fall down the rabbit hole, so maybe they do. Either way, they received a chapter 7 bankruptcy. And then Taekwon Rashi Gullet L also received. So it is ordered a discharge under 11 USC section 727 is granted to Taekwon Rush Gullet L, aka Taekwon Rashi Gullet, aka Malik Rashi L, DBA Taekwon Gullet, DBA Gullet Taekwon, dated July 23rd, 2020 by Jerry A. Funk, United States bankruptcy judge. So they both have received personal Chapter 7 bankruptcy discharges. Now, once again, I don't know what any of this has to do. Remember, this is filed as an attachment, as an exhibit in the involuntary bankruptcy they filed against United States Corporation Company. So them having received their personal Chapter 7 discharges has absolutely nothing to do with this case. I have no idea why they even bring it up. It boggles the mind. But it gets even better. It gets even better, because you should be impressed that I clicked on the right one, the right tab. But in addition to this, I mentioned this earlier, a couple videos ago, but this is going to be the main focus of today's video. And so this is Jerry A. Funk, United States bankruptcy judge. This is his order. So United States Bankruptcy Court, Middle District of Florida, Jacksonville Division, in re Taekwon Rashi Gullet L, debtor. So bankruptcy cases are usually titled in re the debtor. So in regards to, in the matter of the debtor, because there can be adversary proceedings within a bankruptcy, but not necessarily. It's so the main part of the bankruptcy isn't adversary, so it's in re. Although for some reason here, Taekwon Rashi Gullet L versus United States of America et al. Defendants, because he must have tried to do an adversary proceeding in the bankruptcy. And so what's an adversary proceeding within the bankruptcy? Well, let's say I try to discharge my credit card bill in bankruptcy, and my credit card company says, hang on. This is an abuse of the bankruptcy code. You racked up these debts while you were insolvent, therefore you're not eligible to discharge them. You should have to pay them. In order to do that, they're going to file an adversary proceeding against me within the bankruptcy to oppose the discharge of their debt that I owe them. But then let's say I try to get my student loans discharged, because student loans generally aren't dischargeable in bankruptcy. In order to even attempt to get them discharged, I'm going to have to file an adversary proceeding against the student loan companies within my bankruptcy proceedings. So either the debtor or a creditor can initiate an adversary proceeding within it. And so that's basically the lawsuit within a bankruptcy. And it appears that this sovereign citizen attempted it against the United States of America. So that might actually be why, remember, I said I have no idea why he's brought these into this, into the involuntary bankruptcy of United States Corporation Company. But this is probably why. He probably tried to do something in, like I said, it's the adversary proceeding within his personal bankruptcy, again, with the defendant as the United States of America et al. And sovereign citizens believe the United States of America isn't a government, it's not a country, it's a corporation, the United States Corporation Company. So in his mind, the United States of America, is probably the USCC. So that's probably why he included this document, as delusional as it is, within the overarching involuntary bankruptcy that we've been covering. At least that's my guess. So this, remember I mentioned it earlier, that he had documents that were stricken as unintelligible. This is it. So, order striking document as unintelligible. This proceeding came before the court upon a document filed by the debtor, which he titled Letter Rogatory for International Judicial Assistance and Application for ex-rel Action Humanitarian Intervention. The document is 21 pages, handwritten, single-spaced, and unintelligible. The court cannot determine from reviewing the document what relief the debtor, who identifies himself as a political prisoner of war for national liberation from colonialism, seeks. Upon the foregoing, it is ordered the document is stricken as unintelligible. More courts need to do that. When sovereign citizens submit these unintelligible nonsense lawsuits, courts just need to say, look, we can't figure out what relief they're even asking for. This is unintelligible. This is legal gobbledygook. This is jabberwocky. It's why can I never remember the other word that Judge Middleton uses? It'll come to me. But they need to say, this is unintelligible jabberwocky. It's stricken. You can refile if you have a cause of action. And is that procedurally the best? Not necessarily, because, it is an adversary proceeding, but at the same time, if you file nonsense and there's not even a claim made, it should be short-circuited. People shouldn't have to spend money defending themselves against jabberwocky. But then, like you look at the Delete Laws case, it's completely fictional. It's completely frivolous, but he's at least attempting to make claims. So, yeah, it should be mostly 12b6. The rest of it should be disposed of on a summary judgment motion, but it makes sense that LVMPD had to at least respond to that one. This one, what even is a letter rogatory for international judicial assistance? It's jabberwocky. It's nonsense. But while the judge said it's jabberwocky, unintelligible, his handwriting on it is legible. So let's do it. So this is in the Middle District of Florida, in re Gullett L, Taekwon Rush, in alphabetical order, or in all alphabetical and or numerical variations and or derivations, debtor Taekwon Rush Gullett L Plaintiff versus United States of America, United States Attorney General, U.S. Department of Justice, Internal Revenue Service, California Franchise Tax Board, Federal Bureau of Prisons, California Attorney General, American Bar Association, International Bar Association, State of California. Hello, 11th Amendment. United States Department of State, Florida Attorney General, State of Florida. 11th Amendment again. Hey, 11th Amendment says, hey, states are sovereigns and they're immune from lawsuits. United States Treasury, Department of Treasury, United States Department of Commerce, United States Department of Transportation, U.S. Securities and Exchange Commission, U.S. Comptroller of the Currency, U.S. Postal Service, Social Security Administration as defendants. And this is claim number something in bankruptcy, Chapter 7, USPD or USPO priority mail number, letter rogatory for international judicial assistance and application for XREL action / humanitarian intervention, 22 FCR sections 92-54 and 92-66A and Federal Rule of Bankruptcy Procedure 7026, etc. So once again, my handy dandy U.S. Bankruptcy Code. So U.S. Federal Rule of Bankruptcy Procedure, basically in bankruptcy court, you don't use the federal rules of civil procedure because it's not a civil case, it's a bankruptcy case. The federal rules of civil procedure apply to civil cases. But I have here in the back of the book, it has the federal rules of bankruptcy procedure. So, and they fairly mimic the federal rules of civil procedure. So 7026, let's find it. Is a long ass rule. Is so general provisions governing discovery, and Rule 26, Federal Rule Civil Procedure, applies in adversary proceedings. So basically, Rule 7026 is the discovery rule in bankruptcy, but it says, so yeah, we just fully adopt Rule 26 from the Federal Rules of Civil Procedure as Rule 7026 of bankruptcy procedure governing discovery. But like we've discussed many times in the past, Rule 12b-6, the motion to dismiss for failure to state a claim upon which relief can be granted. Well, here we have Rule 7012, which more or less mimics Federal Rule of Civil Procedure, Rule 12. So you can do a motion to dismiss for failure to state a claim upon which relief can be granted, which, you know, if the judge hadn't stricken this, that's probably what these agencies would have done. They would have said, look, we don't know what the hell we're being accused of or what's being sued for, so he hasn't stated a claim against us upon which relief can be granted, so you've got to dismiss. But this is in accordance with the Universal Declaration of Human Rights, 1948, United Nations Declaration of Independence to Colonial Countries and Peoples, General Assembly Resolution 1514 from 1960. United Nations Declaration on the Rights of Indigenous Autochthonous Peoples, 2007. Madrid Convention for Protection in Morocco, 1880. codified at 18 UCS Chapter 7, Section 112. Treaty of Peace and Friendship, 1787. Yeah, that's not going to hold much water in a bankruptcy case. Hague Evidence Convention, 23 USJ or UST 2555. Either way, yeah, Hague Convention on Evidence. The Draganic Constitution for the United States of America. Oh, Organic Constitution. That looked like a D, not an O. So, Organic Constitution for the United States of America, 1787. Article 1, Section 9, codified at 28 USC Sections 2241 through 2256. The Rome Statute, Statute of International Court of Justice, Statute of the International Criminal Court, demand for jury trial. Taekwon Rashi Gullet L., unlawful detainee, political prisoner of war for national liberation from colonialism. POW number, I assume that's his prisoner number. Federal Correctional Institution, Coleman, medium in Coleman, Florida. No phone number. In propria persona, proceeding in sui juris capacity. Applicable to all successors and assigns, I assume up here, yeah, notice to principal, notice to agent, notice to principal, but he wrote in the margins, so it got printed over with the docket information. So Bismillah something Rahman Rahim, in the name of Allah, most gracious, most merciful, on the record and for the record, present is Taekwon Gullet, also called Malik Rush L., divine immortal spirit in living flesh and blood, competent natural man of majority, by firm sound mind and righteous, upright moral integrity, in propria persona, proceeding in sui juris capacity, general, executor, caveator, /settler, /beneficiary, /paramount security interest holder, authenticated birth certificate, registered copyright, registered trademark, United States for America, post office number, registered fictitious business name, Florida Department of State number, maritime lien number, Putnam County, Florida institution number, California UCC number, California UCC number, California UCC number, Kentucky UCC number, over debtor individual Gullet L. Taekwon Rashi. Any and all alphabetical and or numerical variations and or derivations. Hereinafter, affiant. Affiant is a lawful non-immigrant alien within the meaning of Dred Scott versus Sanford. You know you don't have a good argument if you bring up Dred Scott as good law. It simply isn't. But we have footnote 1. C, Central District of California, 2019 case, affidavit for habeas corpus, ground 5, pages 28 through 29. We might have to look that case up, because that affidavit for habeas corpus could be fun. So if I don't remember to do it, someone send that to me. That, like I said, that could be fun. So 8 USC section 1101, aliens, alien, foreign estates, and 18 USC sections 1116 B1, 2, 3, and 4, alien foreign government, alien foreign officials, internationally protected persons, family, irrespective of recognition by the United States. See 4th Judicial Circuit, Duval County, Florida, Probate Registrar Court, Taekwon Rashi Gullet Estate, Notice of Trust Number, Taekwon Rashi Gullet Estate Caveat Number, or the bankruptcy, page 674, Taekwon Rashi Gullet Estate Personal Replevin Claim Number 2. Affiant does rise and give honors and recognition to the noble Quran and Sunnah, the then Holy Quran, Circle 7. We've seen the Circle 7 in their printed in their other documents, or stamped. Zodiac Constitution, AA 222141, A1 Truth. Suhuf Zabur Tara Injil, Great Law of Peace, Treaty of Peace and Friendship, 1787, star. Madrid Convention for Protection in Morocco, 1880, Universal Declaration of Human Rights, 1948, and all annexes thereto. United Nations Declaration on the Granting of Independence to Colonial Countries and Peoples, adopted by General Assembly Resolution 1514 of 14 December 1960. United Nations Declaration on the Rights of Indigenous Autochthonous Peoples, 2007. Rome Statute, Geneva Conventions, Hague Evidence Conventions, Inter-American Conventions, and all annexes thereto. Hague Conference on Private International Law. Convention on the Service Abroad of Judicial and Extrajudicial Documents in Civil or Commercial Matters, from 1965. Apostolic or something convention abolishing the requirement of legislation for foreign public documents, from 1961. Convention on International Access to Justice, 1980. Convention on Choice of Court Agreements, 2005. Convention on the law applicable to trusts and on their recognition, 1985. Convention on the law applicable to certain rights in respect of securities held with an intermediary, 2006. United Nations Covenant, not convention, that's a covenant of civil and political rights, 1966. Vienna Convention on the Law of Treaties, 1969. Organic Constitution for the United States of America, 1787. Statute of the International Court of Justice, ICJ, and Statute of the International Criminal Court, ICC. Sender Malik Taekwon Rashi Gullet L, on behalf of himself, General Executor, Caveator, Settler, Beneficiary, Paramount Security Interest Holder over Gullet L, Taekwon Rashi, any and all alphabetical and or numerical variations and or derivations. 2. Central Authority of I think that's 2. It's cut off on the scan. Either way. Central Authority of Requested State, Mike Pompeo, Secretary of State, U.S. Department of State, U.S. Central Authority for Hague and Inter-American Service Conventions, Office of International Judicial Assistance in Washington, D.C. And 2 persons to whom the executed request is to be returned. A. Ms. Fatau Bensouda, Prosecutor, Office of the Prosecutor, International Criminal Court, Information and Evidence Unit, The Hague, the Netherlands. Ms. Karen Masadi, Head of the Office, Liaison Office of the International Criminal Court to the United Nations in New York at the United Nations Plaza. General Carter F. Ham, CEO Association of the U.S. Army in Arlington, Virginia. Oh, come on. Why is that a bad scan? But something, letters rogatory for international judicial assistance are requested to issue in this adversary proceeding, Maryland, Middle District, Florida, bankruptcy number related to United States Bankruptcy Court, Middle District of Florida, number in accordance with the Hague Evidence Convention, Articles 1, 3, 4, 42, 22 CFR, sections 9254, 9266, blah, blah, blah. Federal Rule of Bankruptcy Procedure 7026, 7027, 7031, 32, 33, 34, 36, 37, 55, 56, 58. Federal Rule of Civil Procedure 26, 27, 31, 32, 33, 34, 36, 37, 55, 56, 58. So remember how I said Federal Rule of Bankruptcy Procedure pretty much mimics the Federal Rule of Civil Procedure. To cause defendants herein listed below to be examined as defendants are within the jurisdiction of the United States. See Barnes & Noble, Inc. versus LSI Corp., U.S. District, so Northern District of California, 2012. See In Re Urethane Antitrust Litigation, Kansas, 2010. The Hague Evidence Convention, Article 42, shows the United States is a signatory thereto and as such will honor letters rogatory and requests issued under the protocols of the Hague Evidence Convention. The defendants to be examined are as follows: United States of America, United States Attorney, Internal Revenue Service, California Franchise Tax Board. We've already gone over the defendants above in the caption, so we're just going to scroll through to the end of the list. Oh, and on United States Trustee, which... Oh, and Equifax and Experian credit bureaus. So those weren't listed above as defendants, but they are now. This proceeding is an adversary proceeding in the Middle District of Florida related to United States Bankruptcy Court, that proceeding, which is a claim of malicious criminal prosecution as a subterfuge for collection of a dischargeable debt, and a claim of breach of trust / breach of fiduciary duty / breach of executory contract. See affidavit for adversary proceeding in Middle District of Florida, bankruptcy number, blah, 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 related to this. Affidavit for habeas corpus in the Central District of California, which, like I said, we need to maybe look that up in a future video. Affiant is a lawful non-immigrant alien within the meaning of Dred Scott versus Sanford. Yeah, no. Who is currently unlawfully / unconstitutionally detained by color of the authority of the United States in violation of the Constitution and or laws and or treaties of the United States, and or being an official of a foreign state and domiciled therein is unlawfully / unconstitutionally detained for an act done or omitted under any alleged right, title, authority, privilege, protection, or exemption claimed under the commission, order, or sanction of any foreign estate or under color thereof, the validity and effect of which depends upon the laws of nations. See notice on page 1, paragraph 1, and the California affidavit for habeas corpus. The highly probative, credible admissible evidence proffered and preferred in the adversary proceeding related to the bankruptcy establishes multiple substantive and procedural violations of due process of law. Due process requires that there be opportunity to present every available defense, but it need not be before entry of judgment. See George Moore Ice Cream Company versus Rose, Supreme Court 1933, which says the estate shall have the benefit of any defense available to the debtor/individual as against any entity other than the estate. And blah, blah, blah. We'll see how far my voice lasts. Affiant asserts all of the following defenses, including without limitation UCC 3-305, defenses and claims on recoupment, duress, illegality of the transaction, fraud, discharge in insolvency proceedings, doctrine of equitable recoupment, abuse of process, breach of trust / breach of fiduciary duty / breach of executory contract, 28 USC section 2256, habeas corpus from bankruptcy courts, self-help repossession / replevin claim, lack of jurisdiction, denial of justice / denial of procedural due process, expropriation / wrongful taking of alien property, doctrine of pacta sunt something or other servanda something, it's cut off, damages / reparations / compensation, international standard of justice, international agreements, application for ex-rel action / humanitarian intervention. Letters rogatory are regularly granted by international customary law for reasons of comity. See U.S. Department of State Regulation 22 CFR sections 92.54 and 9266A. The district court, bankruptcy courts, and the courts of appeal have the inherent authority to issue letters rogatory in both civil and criminal cases. See United States versus Jefferson, Eastern District of Virginia, 2009. The Hague Evidence Convention, Article 42, shows that the U.S. is a signatory thereto. The Hague Evidence Convention is designed as a tool for common law states, S/S states, to obtain civil discovery evidence in civil law jurisdictions. See International Society for Krishna Consciousness, Inc. versus Lee, Southern District of New York, 1984. The Hague Evidence Convention allows letters rogatory may be used by affiant, a lawful non-immigrant alien, alien foreign estate, alien foreign official, to secure evidence from an uncooperative witness / defendant through the compulsory powers of a foreign court, U.S. District Courts, U.S. Bankruptcy Courts, U.S. Courts of Appeal. See Hague Evidence Convention, Article 1. But this isn't a foreign court. This is a U.S. court, and you're in the U.S. The Hague Convention has no bearing. The Department of State has power, directly or through suitable channels, to receive a letter rogatory issued or request made by a foreign or international tribunal, to transmit it to the tribunal officer or agency in the United States to whom it is addressed, and to receive and return it after execution, and to receive a letter rogatory issued or request made by a tribunal in the United States, to transmit it to the foreign or international tribunal officer or agency to whom it is addressed, and to receive it or to receive and return it after execution. See 28 USC section 1781A, transmittal of letter rogatory or request. This section, the 1781, does not preclude the transmittal of a letter rogatory or request directly from a foreign or international tribunal, officer, or agency in the United States to whom it is addressed, and its return in the same manner, or the transmittal of a letter rogatory or request directly from a tribunal in the United States to the foreign or international tribunal, officer, or agency to whom it is addressed, and its return in the same manner. See 28 USC section 1781b, transmittal of letter, rogatory, or request. Affiant does exercise his right to obtain civil discovery, evidence, and propound written interrogatories. I mean, he says, well, we can use the Hague Convention and to get common law discovery from civil jurisdictions, civil law jurisdictions. It's like, but with the exception of Louisiana state courts, the U.S. is common law. So we don't practice civil law in the United States except Louisiana state courts. So, like, even if this were somehow international, you're still dealing with common law. This is just complete and utter bullshit. Yeah. So affiant does exercise his right to obtain civil discovery, evidence, and propound written interrogatories, depositions, and requests for production of documents as is proper, just, and appropriate. See Federal Rule of Bankruptcy Procedure 7026, 7027, 7031, 32, 33, 34, 36, 37, 55, 56, and 58, and the corresponding Federal Rule of Civil Procedures. See affidavit for discovery, interrogatories, and requests to produce. You don't do an affidavit for discovery. You send a request for discovery. What? An affidavit for discovery? And if they don't participate, if you send your request for interrogatories and requests to produce documents, which, remember, we've seen those in Scofield versus Guillard. If you request those and you don't get them, well, with the interrogatories, you might do a motion to compel the discovery, request to produce as well. But like requests for admissions, if they don't produce, you're not going to do a request to compel. You're just going to say, hey, court, they haven't produced it in time. Therefore, it's admitted, like in Scofield versus Guillard. Oh, so see the affidavit, blah, 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 annexed and appended hereto in full by this reference. Affiant's affidavit for adversary proceeding, that's quite the alliteration, in the Middle District of Florida bankruptcy, and affidavits for habeas corpus in Central District of California show good cause to compel such civil discovery evidence for a fair, rounded development of material facts, which show and prove by a preponderance of highly probative, credible evidence that all of Affiant's several related lawsuits filed for just and fair redress of all infringements are all meritorious claims. Affiant has been actually prejudiced and is actually innocent of all alleged criminal charges. Defendants and all privity parties in active concert and or participation are engaged in a pattern and or practice of denial of justice, denial of equality before the law, arbitrary and capricious decisions / actions, abuse of discretion / authority, discrimination and or deprivation and or conspiracy to deprive and or resistance to the full enjoyment of people's constitutionally protected natural rights, human rights, and or civil rights / civil liberties, privileges, and or immunities in violation of international law, the international standard of justice, national law, and personal law. Personal law? Hey. See affidavit for adversary proceeding in the Middle District of Florida, the bankruptcy, and the affidavit for habeas corpus. Evidence to be obtained and or other judicial acts to be performed. Affiant respectfully seeks discovery, specifically interrogatories, answers, and production of documents for the purpose of obtaining evidence. See the long list of rules of procedure, and see affidavit for discovery, interrogatories, and requests to produce, annexed, and appended hereto in full. And that looks like we have footnote 7. Maybe. Maybe not. International Court of Justice and International Criminal Court jurisdiction and venue. Please see affidavit for adversary proceeding in the Middle District of Florida Bankruptcy Court, annexed and appended hereto in full by this reference. Effect of lack of jurisdiction for an action by a state. Please see the affidavit for adversary proceeding, annexed and appended hereto in full by this reference. International standard of justice. Please see the affidavit, blah, blah, blah. Denial of justice, denial of procedural justice. Please see the affidavit for adversary proceeding, blah, blah, blah. And I don't know, that's probably cut off, or maybe it's a continuation. Either way, whatever. Doctrine of pacta sunt servanda. Please see affidavit for adversary proceeding, annexed and appended hereto in full by reference. Damages, reparations, compensation. See the affidavit. International agreements. See the affidavit. Whereas the Universal Declaration of Human Rights guarantees Article 2, everyone is entitled to all the rights and freedoms set forth in this declaration without distinction of any kind, such as race, color, sex, language, religion, political or other opinion, national or social origin, property, birth, or other status. Article 4, no one shall be held in slavery or servitude. Slavery and the slave trade shall be prohibited in all their forms. Article 6, everyone has a right to recognition everywhere as a person before the law. Article 7, all are equal before the law and are entitled without any discrimination to equal protection of the law against any discrimination in violation of this declaration and against any incitement to such discrimination. Article 8, everyone has the right to an effective remedy by the competent national tribunals for acts violating the fundamental rights granted them by the Constitution or by law. Well, if you have the right to remedy by the competent national tribunals, such as the courts, why are you bringing up international law, which is irrelevant here? Article 9, no one shall be subjected to arbitrary arrest, detention, or exile. Boy, I wish we could exile some of these sovereign citizens. Article 14. Apparently, Articles 10, 11, 12, and 13 are irrelevant. But Article 14, everyone has the right to seek and enjoy in other countries asylum from persecution. Article 15. Everyone has the right to a nationality. No one shall be arbitrarily deprived of their nationality, nor denied the right to change their nationality. Article 20. Everyone has the right to freedom of peaceful assembly and association. No one may be compelled to belong to an association, i.e., Social Security, Union States Society. Article 28. Everyone is entitled to a social and international order in which the rights and freedoms set forth in this declaration can be fully realized, i.e., AAMARU, Religious Council Association Testamentary Trust. Whereas the United Nations Declaration on the Granting of Independence to Colonial Countries and Peoples, adopted by General Assembly Resolution 1514 of 14 December 1960, guarantees Article 1. The subjection of peoples to alien subjugation, dominion, and exploitation constitutes a denial of fundamental human rights. Article 2. All peoples have the right to self-determination. By virtue of that right, they freely determine their political status and freely pursue their economic, social, and cultural development. Article 3. Inadequacy of political, economic, social, or educational preparedness should never serve as a pretext for delaying independence. Article 4. Immediate steps shall be taken in trust to transfer all powers to the peoples of those territories without any conditions or reservations, in accordance with their freely expressed will and desire, without any distinctions as to race, creed, or color, in order to enable them to enjoy complete independence and freedom. Whereas the United Nations Declaration on the Right of Indigenous Autochthonous Peoples, 2007, guarantees Article 11, 20, 28, and 32, Indigenous Autochthonous Peoples have the right to just and fair redress by means that can include restitution or just and fair equitable compensation. States shall provide just and fair redress through effective mechanisms. And I should point out, there are a few ellipses here. Just like on Seinfeld, you yada yada'd over the best part. They probably ellipsed out stuff that is damaging to their position. Otherwise, they wouldn't have ellipsed them out. Preamble and Article 37. Indigenous autochthonous peoples have the right to recognition, observance, and enforcement of treaties, agreements, and other constructive arrangements concluded with states or their successors, and to have states honor and respect such treaties, agreements, and other constructive arrangements. Article 39. Indigenous autochthonous peoples have the right to have access to financial and technical assistance from states through international cooperation for the enjoyment of the rights contained in this declaration. Article 40. Indigenous autochthonous peoples have the right to access to and prompt decision through just and fair procedures for the resolution of conflicts of law and disputes with states or other parties, as well as to effective remedies for all infringements, that's double underlined, so emphasis added, of their individual and collective rights. Article 43. The rights recognized herein, this declaration, constitute the minimum standards for survival, dignity, and well-being of the indigenous autochthonous peoples of the world. Whereas the Madrid Convention for Protection in Morocco, 1880, guarantees in Article 15 that the default status of all Moors is to the Al-Moroccan Empire, and said status can only be forfeited upon completion of a naturalization process to the United States after obtaining the informed consent of the Al-Moroccan Empire. See Dred Scott versus Sanford. Free Moors are not citizens of the United States and cannot become a citizen of the United States. Citizens are natives or naturalized. All persons born in the United States are not citizens. Once again, this is Dred Scott. We fought a civil war after Dred Scott. We had the 13th, 14th, and 15th Amendments passed after Dred Scott. Dred Scott is not good law. We have birthright citizenship now for everyone born here. I mean, sovereign citizens, you know, they argue, I'm not a 14th Amendment citizen. But the 14th Amendment granted citizenship to everyone born within the United States. So when he quotes Dred Scott from 1857 saying all persons born in the United States are not citizens, that's false. That is superseded. That is old bad law. This is ridiculous. But the exceptions are Indians, autochthonous, and in general, Moors, people of color. Persons who are not citizens can only become such by virtue of naturalization. The power of naturalization is exclusively vested in Congress. See affidavit for habeas corpus. And once again, he says naturalization is exclusively vested in Congress. Well, Congress and the states enacted the 14th Amendment. Whereas the Treaty of Peace and Friendship, 1787, guarantees in Article 16, in case of a war between the parties, Moors and the United States, the prisoners are not to be made slaves, but to be exchanged one for another. And if there shall prove a deficiency on either side, it shall be made up by the payment of 100 Mexican dollars for each person wanting. And it is agreed that all prisoners shall be exchanged in 12 months from the time of their being taken. See Petition for Rehearing, Supreme Court, 18-6630, with third letters rogatory / letters of request for international judicial assistance et al. See affidavit for adversary proceeding and peace and Treaty of Peace and Friendship and Exhibit C. But so he wants to be sent to Morocco. That's what I understand from this section, because the Treaty of Peace and Friendship guarantees, well, we're not at war with Morocco, but that prisoners are not to be made slaves, but to be exchanged one for another. So basically, he wants us to exchange him for an American being held prisoner in Morocco. Is that what I understand? The Moroccans are not going to appreciate you cosplaying as a Moor. They don't like it. They don't claim you. They think you're wackadoo. You will not have a good time if you get exchanged to Morocco. Based upon all of the foregoing, affiant proffers and prefers evidence and charges to the International Court of Justice and International Criminal Court that officers, agents, employees, subsidiaries, and all privity parties of the United States Federal Corporation in active concert and or participation are engaged in a pattern and or practice of war crimes under the law of nations, grave breaches of the foregoing and following international law, international standard of justice, Geneva Conventions, Hague Evidence Conventions, Inter-American Conventions, felonies, high crimes and misdemeanors under color of law, i.e., assault on alien foreign officials slash family, attempted murder, duress, oppression, genocide, kidnapping slash abduction slash false imprisonment, human trafficking, mail fraud slash mail tampering, tampering with evidence slash witnesses slash informants, retaliating against witnesses slash informants, conspiracy slash deprivation of rights under color of law, peonage, slavery, involuntary servitude, piracy under the law of nations, trusts slash monopolies in restraint of international trade, denial of justice, denial of equality before the law, arbitrary and capricious decisions slash actions, abuse of discretion slash authority, discrimination and or deprivation and or conspiracy to deprive and or resistance to the full enjoyment of people's constitutionally protected natural rights, human rights and or civil rights slash civil liberties, privileges and or immunities in violation of international law, international standards of justice, national law, and personal law. See affidavits for habeas corpus. See letter rogatory for international judicial assistance and application for ex-rel action, humanitarian intervention in the Central District of California. So he's tried this shit in California too, in the criminal case. Fun. And the affidavit for adversary proceeding in the bankruptcy case. Wherefore, in an exercise of the realization of the natural rights and human rights enumerated in the Universal Declaration of Human Rights, 1948, United Nations Declaration of Independence to Colonial Countries and Peoples, 1960, United Nations Declaration on the Rights of Indigenous Autochthonous Peoples, 2007, Hague Conference on Private International Law, Convention on the Service Abroad of Judicial and Extrajudicial Documents in Civil or Commercial Matters, from 1965, Apostille Convention abolishing the requirement of legislation for foreign public documents, 1961, Convention on International Access to Justice, 1980, Convention on Choice of Court Agreements, 2005, Convention on the Law Applicable to Trusts and Their Recognition, 1985, Convention on the Choice of Law Applicable to Certain Rights in Respect to Securities Held with an Intermediary, 2008, United Nations Covenant of Civil and Political Rights, 1966, Vienna Convention on the Law of Treaties, 1969, Madrid Convention for Protection in Morocco, 1880, and Treaty of Peace and Friendship, 1787. Affiant respectfully invites the assistance of the International Court of Justice, International Criminal Court, Ms. Fatou Bensouda, Office of the Prosecutor, Ms. Karen Masadi, Head of Liaison Office of the ICC to the UN, United Nations, including without limitation the Permanent Forum on Indigenous Issues, the bodies, organs, and specialized agencies of the United Nations system. It's funny to me that he's asking the United Nations for help when the UN is frequently the biggest boogeyman for conspiracy theorists. Definitely not going to make it past this article, this document. Where was I? Okay. In the nature of an ex-rel action / humanitarian intervention for special public prosecution and for such equitable relief as may be appropriate to ensure the minimum corrective measures necessary, including, without limitation, financial assistance and technical assistance, access to and prompt decision through just and fair procedures for the honorable resolution of this action and the entirety of the directly related actions, as well as access to effective remedies for all infringements. See affidavits for habeas corpus, and see letters rogatory for international judicial assistance and application for ex-rel action / humanitarian intervention, Central District of California. Ninth Circuit Appeals docket number. Someone look that up. See Supreme Court number 13-9138, petition for rehearing with affidavit for modification of detention order and judicial notice of adjudicative facts. See Supreme Court number 18-9138, supplemental brief. See Supreme Court number 18-9138, petition for writ of certiorari, writ of cert. See Supreme Court number 18-6630, petition for writ of mandamus. See Supreme Court number 18-6630, petition for rehearing with third letters rogatory for international judicial assistance et al. See District of DC 19 civil case in 2019, DC Court of Appeals or DC Circuit Appellate Court, something or other, affidavit for judicial review and enforcement, second petition for writ of something, sire fascia, I don't know what the hell that is. And see DC Circuit number 19-1149, affidavit for judicial review and enforcement and petition for writ of same thing, sire fascius, no idea. Affiant respectfully offers his fourth Judicial Circuit Duval County, Florida Court accepted and executed personal replevin silver bonds. Each bond is 20 silver trade dollars, 900 fine, numbers blank, annexed and appended to Affiant's Universal and International Humanitarian Declaration for Common Law Prejudgment Writ of Personal Replevin, original case number, and filed into Central District of California, criminal case as surety bond with collateral, supersedeas surety bond, mandatory judicial notice of act of surety, judicial notice of silver bond, judicial notice of fiduciary appointment, and judicial notice of maritime lien and invoice contract under seal international agreement as security to the ICJ, ICC, and UN in the nature of a supersedeas surety bond. Note, the term trade dollar means United States dollar coin made of silver for use in foreign alien trade. For the purpose of this letter rogatory for international judicial assistance and application for XREL action / humanitarian intervention, a dollar is defined as 1 ounce, a 1 ounce silver coin, 0.9999 fine, or par value in United States Red Seal silver certificates issued by the United States Treasury Mint in accordance with Executive Order 11110. Okay, we'll have to take a look at that before we end, because I know what that is. See affidavit for adversary proceedings, Middle District of Florida bankruptcy, appendix, documentary evidence, E, executive order. Affiant further respectfully invites all such other relief, intermediate relief, and further relief in accord with natural equity for the honorable resolution of this matter as law and justice require. In honor, Amin. Commercial certification. I, Taekwon Gullet, also called Malik Rush L, divine, immortal spirit in living flesh and blood, competent natural man, and majority by firm, sound mind, and righteous, upright, moral integrity, in propria persona, proceeding in sui juris capacity, general executor, caveator, settler, beneficiary, paramount security interest holder, authenticated birth certificate, registered copyright, registered trademark, United States of America, post office number, registered fictitious business name, Florida Department of State number, maritime lien number, Putnam County, Florida institution number, California UCC 10 something or other, and another California UCC, Kentucky UCC number, over debtor / individual Gullet L, Taekwon Rashi, any and all alphabetical and or numerical variations and or derivations, do hereby declare and affirm under penalty of perjury, under the universal law of our most high divine source of the force, universal Allah, the exalted and majestic, then under the laws of the United States, that the foregoing is true, correct, certain, complete to the best of my own first-hand personal knowledge, not misleading, admissible as evidence, and in accord with the righteous, upright moral integrity of my honorable intent. And if called upon to offer rhetoric and testify as to the veracity of the evidence herein proffered and preferred, I shall so state. 28 USC section 1746, Federal Rule of Evidence 301, 902, 10. This affidavit is dated on or about the 11th day of Rajab in the Moorish calendar year of our most high divine source of the force, universal Allah, the exalted and majestic 1441, Gregorian calendar year 2020, March 6th. Witness my hand and seal, under protest, without prejudice, under reserve, and with reservation of all our rights. Malik Taekwon Rashi Gullet L, autochthonous American, Moor, alien, something or other, UCC 1-308. Malik Taekwon Rashi Gullet L, general executor, caveator, settler, beneficiary, paramount security interest holder, over Gullet L. So that was signed in mixed upper and lower cases, but over all caps Gullet L, Taekwon Rashi, and any and all alphabetical and or numerical variations and or derivations. Political prisoner of war for international liberation from colonialism, unlawfully detained and falsely imprisoned at Federal Correctional Institution, Coleman, Medium, in Coleman, Florida. I, Taekwon Gullet, also called Malik Rush L, general executor, blah, blah, blah. Looks like the same thing. But he served the defendants, apparently. Must have had to provide a lot of favors to get all the postage stamps for that. My goodness. And so, yeah, that's all we need to cover of that document. But despite me saying I was going to be done, we do have I don't think we need to. Oh. So we might do that next time. But like I said, so this I think is the thing he was mentioning, the executive order 11111 something or other, and it's got his social security number, so I don't want to do above that. But to whomever United States business entity this may concern, who commercially operates on United States public markets and accepts or exchanges in United States currency while providing goods and or services to U.S. customers / consumers in everyday commerce, the above mentioned U.S. federal public person has a prepaid, non-obligatory commercial debt obligation arrangement with the United States in relation to 12 U.S. Code Section 95A, regulation of transactions in foreign exchange of gold and silver, property transfers, vested interests, enforcement and penalties, and other public policy on U.S. debt. Your business entity is federally bound to United States and U.S. public debt obligations by way of your Internal Revenue Service employer identification number, the IRS being under the U.S. Department of Treasury, and your Federal Reserve business bank account. Your business is hereby ordered to itemize whatever and however many commercial products and or services in which the above U.S. federal public person wishes to commercially acquire, adjust the bottom line total cost amount to $0 and release the items. Provide a receipt to the above U.S. federal person by way of its duly authorized representative, Raj Raphael, sui juris de jure improper person, and retain the record of the transaction to settle with your federal tax obligations with Internal Revenue Service, as the entire overall transaction is only a commercial accounting matter of what the bankrupt United States owes its true creditors, which is the American people, in direct relation to the Borrowed Gold and National Banking Emergency Act of 1933. All commercial public debt obligations while transacting all business within the United States or within United States commercial markets belong to the United States, as the United States is the true obligor in each and every U.S. commercial transaction. Any willful dishonoring and or non-settlement of United States commercial public debt obligational matters by any duly bound commercial business entity within the United States will result in federal prosecution to the fullest extent possible. Sincerely, Donald J. Trump, President, Chief Executive Officer of the United States. And that is Donald Trump's signature. I have a feeling that this is a forgery, a fake, a fraud, a nonsense put together by these sovereign citizens. Because, number one, if Donald Trump sent this letter, it would be so monumentally unconstitutional of an order that it would have been in the news. I guarantee it. So I think this is just the sovereign citizens trying to commit fraud and receive free goods from businesses under the threat of federal prosecution to the fullest extent possible for not giving me everything I want to commercially acquire with a total cost amount of $0. They're trying to commit fraud. They're trying to fraudulently obtain goods or services, and they're trying to use the authority of a former president who wasn't a former president at the time to do so. They could be prosecuted for this. They very well may have been. It's ridiculous, it's asinine, and it's laughable, but it's serious. It's a crime. But with that being said, my voice is shot. So I'm going to leave you here. I had fun with this one. I hope you guys did too. We're, other than those long things we skipped, we don't have a whole lot left in this, but this might just be the beginning of the Taekwon, Rashi, Gullet, L rabbit hole, because apparently there's a whole lot more federal cases we need to do concerning him, because he is nuts and litigious and just, yeah. But I said we're almost done with that, but I lied. I lied, because, well, we do have a few more attachments. We're almost done with docket 1. We still need to do docket 28, the motion to dismiss, because the lawyers for the purported involuntary debtors didn't hold back. They called it frivolous. I mean, it is frivolous, but so yeah, we do need to do that. And we might also do the order granting the emergency motion to dismiss. Ooh. This one could be fun too. Order enjoining petitioning parties, so the sovereign citizens, to order to show cause, 1, why Chapter 11 involuntary petitions should not be dismissed, and 2, why petitioning parties should not have to post a bond, and 3, whether petitioning parties should be sanctioned pursuant to Bankruptcy Rule 9011 and 11 USC Section 105A. So remember, Bankruptcy Rule 9011 would be the equivalent of Federal Rule of Civil Procedure, Rule 11, which is sanctions, and a few other things, but sanctions is the important bit. And so, yeah, either way, we still have a few more things to go over, a few other filings after we've finished what we're going to do with document 1, but that might not be the next video. No guarantees. So with that, thank you for joining me. Like I said, this one has been fun. This whole series has been a lot of fun for me. You may notice I've been dripping with sarcasm and condescension reading it, but please do all the standard YouTube-y things like share, subscribe, bribe your friends and family to do the same. And with that, I am going to rest my voice and see you later. Bye-bye.